Dielmann versus Infinity Lifestyles, case 844348. We have here in court. Once you have a chance to get to council table, have you make an appearance, then we'll see who we've got remotely, please.
Good morning, Your Honor. Tyler Watson on behalf of the Real Water defendants.
And remotely, please. I'm going to do alphabetical order. Let's do A through K first, and then we'll do the rest of the alphabet.
Good morning, Your Honor. Melanie Hill appearing on behalf of Tyler Dielmann.
I thought we had one other counsel on this case. No?
I
There
am, Your Honor.
is.
but I'm after K though.
I'm not hearing what whoever is speaking, we're not hearing you. Can you please repeat what you said and a little closer to the microphone so we can hear you, please?
Your Honor, this is Thomas Valet for the plaintiff Dielmann. Pro hoc vice.
Okay, thank you. Okay, so in court, feel free to sit down, stand up, whatever's comfortable for you.
Thank you, Your Honor.
So they're doing it remotely, right? Okay, so let's go where we're at for today's case. Today's case, as you know, today is the status check on this case. There was a brand new notice of appearance filed on 12/2/2024, which is probably why I have you, counsel. So are you, because it says you make your appearance on behalf of Affinity, but it doesn't say co-counsel, replacement counsel, what? Since I just have you here, that's nothing negative about just having you, it's just, it doesn't say.
At this time, the Woodsmith firm is staying on. There's a chance that they will move on at some point, but right now they are still involved in the case.
Okay, we're just trying to make sure for our notices and things like that, and just if not, then we need you to clean up from the clerk's standpoint, just so make sure everyone's getting appropriate notifications. Okay, so the last thing this court has from you all, right, is the 5/14/2024 status report. And like I said, since that was prior, well, it's co-counsel for defendants, right, on 5/14. This court needs to know what's going on with this case and what is going to happen, because back in May, you know, it's been a long time since then. So who's going to give the summary of the current status so that we know what we can get taken care of with this case? Because as you know, you're going to trial April 21, 2025. Yes, you have a preferential for two huge reasons. One, it's a B case. Two, even though there was certain stay type issues, it's a 21 case. So yes, you're going unless there's something that takes it outside of this court's jurisdiction, right? Or some other good cause that I'm not aware of. So with that in mind, who wants to give the court the status check, which is today, a status update?
I will, Your Honor. Thomas Valet for plaintiff Dielmann. Your Honor, the case is trial ready. The parties have stipulated to the issues to be tried, which relate to causation and damages. The parties have exchanged experts and expert reports, and the case is trial ready. And I appreciate your comments regarding proceeding on the 21st, Your Honor. But I did speak with defense counsel last week about requesting a continuance of the court, and the reason is as follows. As I believe Your Honor is aware, the limited insurance that Real Water has is the subject of motion in bankruptcy court as to how that money will be distributed. The bankruptcy court has still not decided how the insurance proceeds will be distributed, meaning whether it will be paid out on the judgments that have already been entered against Real Water, or whether there will be some pro rata apportionment of the insurance proceeds to all claimants. Those motions have not been decided by the bankruptcy court. If the bankruptcy court were to decide that the insurance, the available insurance, is going to be paid on the judgments, there would be no money to be paid on any judgment that the plaintiff Dielmann would obtain. And so if we go through this trial in April and he obtains a judgment and the bankruptcy court ruled that the insurance is going to be paid on the pre-existing judgments, then the trial really is just a waste of everybody's time and money and effort. If the bankruptcy court, however, does decide that it's going to be pro rata, then there might be some reason to have a trial in the Dielmann case. I can tell you that if the bankruptcy court were to decide that the money is going to be paid on the existing judgments, it's likely that Mr. Dielmann would not proceed with his case to trial because there would be no point. So that's really the basis for this request for a potential continuance, Your Honor. It's really just to conserve the court's time, counsel's money for the experts, which is all contingent on the bankruptcy court issuing this decision that we've all been waiting for.
Okay. Well, a couple of different things. First off, please, and I appreciate your pro hoc vice counsel, so probably your local counsel has told you that you can't make an oral request after discovery is closed because there's specific case law, right, on what needs to be done and the standards that need to be done in order for said request to come to the court. So I cannot consider that today because according to the trial order, it appears discovery closed on December 23rd, 2024, which triggers a lot of different things and what parties need to do. So I'm hearing what you're saying, but you can appreciate the rules have a specific requirement about what needs to be done if you wish that to be presented to the court. Okay.
Your Honor, may I interrupt you? And I apologize.
Oh, you may not interrupt me, please, because we want to make sure everyone has a nice, clear record, right? And also it's just not polite to interrupt people, but so that is where it is. I'm now going to go to defense counsel because they have an opportunity to provide their status update, and then I'll circle back for anything that you wish to be heard on. Go ahead, please, counsel for defense.
Thank you, Your Honor. Yeah, so just a few things to echo what Mr. Valet had said. This matter is ready to go to trial. My office was recently retained to come in and start trying these cases. We've got one in February in front of Williams. We've got one in March in front of Hardy. We've got one in April in front of you. Our schedules were cleared to make sure we could comply with this schedule, this aggressive trial schedule, and we are ready to go. That said, Real Water, as you are aware, is out of business. It's in bankruptcy and has very limited insurance funds. I'm not opposed to a motion that plaintiffs would file to prevent this trial from going forward or continuing it. But as you've indicated, it needs to be a request from, a formal request in the form of a motion. So we don't stand in opposition to that, but we're also ready to go in the event that's what this court decides.
And the same thing I'm going to ask counsel for plaintiff. I mean, this court is very well aware about the number of cases that are going forward. This concept of it shouldn't go forward because of bankruptcy trustee, right? While the court did allow the first continuance, right? Because you all told me the bankruptcy court was meeting on May 16th, 2024. When I say you all, you weren't in the case, but I'm reading straight from the status report, right? Line 18, on page 2. So all the other cases are going forward. Now, some have been consolidated, so they may be going forward a bit differently, but they're going forward. And so the court, I will tell you, has to evaluate, if I get a proper request, the fact that other cases are going forward and that have to evaluate what the rules provide on the idea of what that is. But the court, of course, can't make any determinations until it sees something properly before it, which analyzes the factors that are required under applicable case law and the rules. So, but did you want to address, I mean, other cases are going forward, as you noted, and the
So
court's
there,
aware of that because one of my consolidated cases is now going forward in a different department, right?
May I be heard, Your Honor?
yes.
No, counsel for defense, I asked him a question. I'd like him to have an ability to please respond.
So there are settlement discussions that
I-
are taking place, but yes, the February trial in front of Judge Williams is anticipated to go forward as scheduled. We have a firm date starting November 24th. Sorry, February 24th. So we'll be going forward on that. There is a discussion about the next matter, which is also being handled by Will Kim's office of doing a stipulated judgment on that. So we anticipate that one will go away, but currently it is scheduled for March. I actually have a status hearing on that in half an hour.
Okay.
So yes, you are correct. Other matters are continuing to advance.
Okay, thank you. Okay, so counsel for plaintiff said, let you have an opportunity you wanted to give some other comments. Feel free to do so, but do realize any request for any continuance needs to comply with the rules and applicable case law and cannot be heard today without such under the rules and applicable case law. Go ahead, please.
Thank you, Your Honor. Again, Thomas Valet for Plaintiff Dielmann. And local counsel did advise me of the necessity for a written motion. My comments today were really just to make the court aware of this request and to sort of gauge the court's willingness to entertain the motion. There is a difference between this case and some of the other cases that are scheduled for trial in that Real Water is the only defendant in this case. Mr. Dielmann purchased his water directly from Real Water. There are no other defendants such as a big box store or other parties with insurance that would necessitate a trial or even a settlement. This case cannot be settled because Real Water is the only defendant, and many of the other cases have other defendants against which the trials have meaning. So that's the difference between this case and the other cases, Your Honor.
Okay, well, I'll appreciate from a status update standpoint as indicated, if there's any request of the court. You all chose not to do anything before discovery closed, so need to follow the applicable case law and the applicable rules of what needs to be done given this particular time period. But just for one point of clarification, this is a stack date for 4/21/2025. There has not been a firm date to commence on 4/21/2025. If you look at your trial order, it says you are on the stack of 4/21/2025. Correct. At least I did not see, if somebody thinks that there is something in between that it says it is actually commencing on the 21st, somebody needs to let this court know. What was this court's understanding and preparing for today and looking at the trial order, that it is a stack date, because in this case, unlike other cases, nobody had requested a specific firm date. So what we did is to accommodate other departments. And once again, since these were coordinated for discovery purposes, back when this was set, it was based on a series of cases where the various counsels for the various parties wanted things on particular stack dates, and then some subsequently went to firm dates. Wasn't sure if everyone was familiar with that, but so you're on 4/21/2025 stack. Like I said, since you have priority both from the age of the case and it being a business court case, the court, let's see, I can quickly, 1 second. If it's of any help to the parties, I can quickly see how many cases. There's only 9 cases on that stack, which is a low number anyway. And yes, I was correct. I just was double checking. You are the oldest even of the business court cases, so be first for evaluation, and you're only a 10-day trial, at least that's what the court had been told previously, that it was only a simple 10-day trial, so it didn't impact too many other things. And since we've got 5 weeks, looks like there's plenty of time. Okay. Do appreciate it at this juncture. Wish everyone, like I said, some of you have not seen since the holidays. So I hope everyone had a nice holiday, whatever you're celebrating, and a happy new year. And we will see you right now. Next thing we show is for the 3/20/2025 pretrial conference. And that is the date in which all the trials on the stack do actually get set within said stack. So please ensure that you communicate with all of your experts, all of the various individuals, to see the mutual availability, because the first thing we go through, right, since I said you're the oldest in a business court case, that means you're likely to be asked first on the 20th as far as your availability. Okay.
Thank you, Your Honor.
Thank you, Your Honor.
Appreciate it. Thank you so much. All the best. That concludes page 26.